Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website, as well as those joining us on C-SPAN TV this afternoon. For those in-house, we would ask that courtesy to see that our mobile devices have been silenced or turned off as we begin. And, of course, anyone watching online is welcome to send a question at any time, simply emailing speaker@heritage.org. Hosting our discussion this afternoon is Tiffany Bates, Legal Policy Analyst in our Edwin Meese III Center for Legal and Judicial Studies. She researches and writes about the courts, judicial nominations, and other constitutional issues. She is also a co-host of Heritage's SCOTUS 101 podcast. She is a regular contributor to the Daily Signal, Heritage's multimedia organization, and she also coordinates the Meese Center's appellate advocacy programs. Please join me in welcoming Tiffany Bates. Tiffany?
Thank you and welcome to the Heritage Foundation, and thanks for joining us to celebrate Free Speech Week by highlighting recent First Amendment victories for beer, bands, and hopefully, as we'll discuss later on, sports. I'll keep my remarks and introduction short so we can get to what we're all here for, the beer. This summer, the Supreme Court reiterated that the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. While the freedom of speech has long been the core of our free society, it has recently come under sharp attack. The courts, however, have pushed back over the last few years, continually extending First Amendment protections for what some would call offensive speech. Today, we'll highlight 3 cases. First, we'll hear about Flying Dog Brewery's 6-year fight with the Michigan Liquor Control Commission after it denied Flying Dog's application to register a beer label for one of my favorite beers, Raging Bitch. We'll then see a short video from Simon Tam, bass player of the Chinatown dance rock band, the Slants, who took their case all the way to the Supreme Court this year, after the Patent and Trademark Office refused to register their band name under a law prohibiting registering trademarks that may be disparaging. In a unanimous win for the Slants, the Supreme Court found the disparagement clause of the Lanham Act violated the First Amendment. Justice Alito wrote for the court that such a law offends bedrock First Amendment principles. Speech may not be banned on the ground that it expresses ideas that offend. Finally, we'll talk about the fate of the Washington Redskins' 6 trademarks that the government canceled under that same disparagement clause. After the Supreme Court handed down its opinion in the Slants case in June, all parties to the Redskins case and the Department of Justice sent letters to the Fourth Circuit stating that the Slants case controls the disposition in the Redskins case and that the court must enter judgment for the Redskins. It's been 4 months, but the Fourth Circuit has not done so. Is the court just taking its time, or is it trying to distinguish the Slants case in order to rule against the Redskins? We'll explore the future of free speech with our great panel of experts. Jim Caruso is the CEO and general partner of Flying Dog Brewery, leading the company since its founding in 1994. Flying Dog, the 32nd largest brewery in the country, is known for its world-class beers combined with distinctive label art created by artist Ralph Steadman. Jim is as passionate about the First Amendment as he is about the beer he produces, and he's been an advocate for the freedom of speech since the 1970s. In 2015, using damages awarded to Flying Dog by Michigan after its court battle, Jim founded the First Amendment Society, a nonprofit whose mission is to raise the public's awareness about First Amendment principles. Jim has been the recipient of numerous awards for both his business prowess and his dedication to the First Amendment. He holds a bachelor's and a master's degree in economics from the University of Missouri, and he holds a degree in brewing science from the Siebel Institute. Trevor Burrus is a research fellow in the Cato Institute's Robert A. Levy Center for Constitutional Studies and managing editor of the Cato Supreme Court Review. His research interests include constitutional law, civil and criminal law, legal and political philosophy, and legal history. His writing and academic work has appeared in many news outlets and journals across the country. He's also the co-host of Free Thoughts, a weekly podcast that covers topics in libertarian theory, history, and philosophy. Trevor holds a BA in philosophy from the University of Colorado and a JD from the University of Denver. And finally, Eric Jaffe is an appellate litigator with a practice covering a wide variety of legal issues in both state and federal appellate courts. Since starting his own practice in 1997, Eric has been involved in appeals on a broad range of legal issues, including the First, Second, Fifth, and 14th Amendments, and other state and federal constitutional and statutory matters. Eric has been involved in over 100 Supreme Court matters, including filing 30 cert petitions representing half a dozen parties on the merits, and filing over 60 amicus briefs at both the cert and merit stage. Eric holds a BA in molecular genetics from Dartmouth College and a JD from Columbia. He served as a law clerk to Judge Doug Ginsburg on the D.C. Circuit and Justice Clarence Thomas on the Supreme Court. So with that, we'll hand it over to Jim.
Thank you, Tiffany, for inviting me to be on this panel, and thank you to the Heritage Foundation for the fine work that you do on a day in and day out basis. So, as most of you know, and probably better than I, free speech as we know it today didn't really exist before the 1960s. I'm a child of the 50s, so I observed the development of First Amendment law. And by the 1970s, I was passionately committed to the principles of the First Amendment, both as one of the most basic human rights and the First Amendment as the rock star of the Constitution, as Floyd Abrams describes it. The master freedom, the foundational freedom for intellectual freedom, political freedom, and economic freedom. Where the First Amendment and my business intersected was first in 1995, when we released a beer, Road Dog, with original label art by the internationally famous artist Ralph Steadman. We knew Ralph through our connections with Hunter S. Thompson, and Ralph was painting this label live on the BBC. There's a fun backstory behind it, but in partly an effort just to poke the BBC a little bit, and as it related to an essay that Hunter wrote for the release of this beer, he scribbled on there in his inimitable fountain pen font, "Good beer, no shit." We received the label and loved it, and laughed just as you did. We released it in Denver, Colorado. Got huge press, both for the beer and the distinctive label art. This is back in 1995. But a competitor complained to the Colorado Liquor Commission that the word shit was an obscenity. And so the Colorado Liquor Commission agreed and demanded that we remove the product from the shelf or they'll suspend our license. So we pulled $250,000 worth of beer from the shelf, re-released the beer with good beer, no censorship. Not surprisingly, sued the Colorado Liquor Commission, and 6 years later, the Colorado Supreme Court overruled the Colorado Liquor Commission. Shit is simply not an obscenity. In 2009, we released a beer, again, thank you, Ralph, with original label art, and the name of the beer is Raging Bitch. As some of you may or may not know, most states require some sort of submission of labels before you sell the beer. It varies by state. It's a routine administrative process. We do hundreds of these per year. Unbeknownst to me, this beer was not approved for sale in Michigan. It was rejected, and we had shipped some. It was a mistake. Michigan's response was clear and immediate. If we don't remove the beer from the shelves within 24 hours, the state police will be sent out to confiscate it, and I could be charged with a felony. We removed the beer. I appealed the decision of the Michigan Liquor Control Commission. And for all of us who are concerned about and cherish our constitutional freedoms, we should be somewhat concerned with some of the reasons they gave for not liking this beer. Well, they didn't like anything about it, by the way. The name, the art, or the label copy. But some of the reasons at the appeal hearing were that Oprah Winfrey does not allow that word on her show. Wonderful. I'm waiting for a reference to the Constitution because they've already assured me this is not a First Amendment issue. Another thing that they told me was that the Westminster Kennel Club no longer uses that word to refer to female dogs. Okay, I get it. They also said that it has to be removed from the shelf because the mere passive observance of this beer on the shelf will incite people to violent action. What I didn't know at the time was that for years, the Michigan Liquor Control Commission had rejected any beer, wine, or spirit that had the word bitch in it, simply because they didn't like the word. And of course, the bedrock principle of the First Amendment is that the government cannot control or suppress speech just because they don't like the content of it. Not surprisingly, we sued the state of Michigan, the Michigan Liquor Control Commission, and the commissioners as individuals. It was in the Western District, was the first hearing, and the ruling was in favor of the Michigan Liquor Control Commissioners, and the court extended to them both quasi-judicial and judicial immunity. Basically saying, not really sure if this is a violation of your First Amendment rights, but it doesn't really matter because they're immune from being sued. That was then appealed to the Sixth Circuit, and after 4 more years of waiting, the Sixth Circuit ruled unanimously in our favor, with the dissenting but concurring opinion further saying not only are they liable to be sued for their violation of, possible violation of Flying Dog's First Amendment rights, but they, in fact, this is a clear, blatant violation of Flying Dog's First Amendment rights. We went back, settled with Michigan. I used the proceeds of that to create the First Amendment Society. It's a nonprofit. It's rather new, but we've endowed a speaker series. So we have constitutional attorneys, law professors speaking about everything from FCC regulations to current issues relating to the First Amendment. We are sponsoring a scholarship for investigative journalism at the University of Maryland. I work in conjunction with a lot of liberty-oriented groups to speak at free speech events and at college campuses. So this is a big part of what we do. In short, why is a brewer here talking about the First Amendment? Because I've spent 12 of the last 22 years in litigation or in courts suing states because they personally didn't care for a beer label. Thank you.
Next, we'll watch a short video from Simon Tam, who is sorry he can't join us in person.
Hello from Sydney, Australia. My name is Simon Tam, founder and bassist of the Slants, the world's first all-Asian American dance rock band. And I'm sorry I can't be there in person to join you today. I started this band over a decade ago because I wanted to create something that would empower Asian American communities. But it ended up being something that took me to legal battle that lasted 8 years against the U.S. Patent and Trademark Office. I originally chose the band name so long ago because I wanted to change something that was a point of shame for me as a kid to a symbol of empowerment as an adult. That the stories of me surviving being bullied and physically assaulted from other students would resonate with other marginalized communities who've also had a difficult time with their identities. So we wanted to reappropriate this outdated, kind of obscure racial slur that wasn't even that popular to begin with. The term historically was used as slant eye against Asian Americans, but it was a term that our community started to use instead in the 80s and 90s as a point of pride instead. So as a musical project, we thought it would be perfect. Sounded like a band that Debbie Harry would front. We originally applied for this trademark 8 years ago because it's something that's really important for bands to do. It's a normal part of their career. As you're making national headlines, you just go ahead and register the mark so you can protect your brand. The whole point of the trademark system is to actually protect consumers. It wouldn't help folks if there were 10 bands out there all with the exact same name. So we created a system where people can apply for it, protect their intellectual property rights, and also make sure that there aren't imitators. That way, if you're buying concert tickets to see one band, well, you can be assured that it is the right band. Same thing if you buy any other kind of product out there. So it's not really traditionally been a place for the government to decide morality on. It's more of a filing system. If you meet all the requirements of your business, then you should be able to have a legitimate business and protect those interests. For us, that simple process changed into a much larger fight when the government decided that they would know what was best for the Asian American community. They told me that the name the Slants is disparaging to persons of Asian descent, even though we had no complaints from our community. Now, for the government to deny you rights based on this kind of claim, they have to find that a substantial composite of the group finds it offensive, so in this case, Asian American. But throughout the last decade, they did not find a single Asian American who was upset by our name. They instead relied on wiki joke websites like urbandictionary.com, asianjokes.com, and quoting from anonymous posts on 4chan and other kind of message boards. When we decided that they wanted to strip the agency of our ability to determine what's right for ourselves, we decided to appeal and continue fighting. And after we brought independent national surveys, linguistics experts, including one of the editors of the New American Oxford Dictionary, and over 3,000 Asian American leaders standing up and telling the government that they were actually wrong on the issue, well, we still lost. The government decided that they knew what was best. So we started asking them questions like, hey, if slant is an inherent racial slur like you claim it is, why have you registered it so many times before? There are literally hundreds of applications for the term slant, with many of them being registered. Mine is the only case in all of U.S. history to be denied slant on the grounds that it's offensive to Asian people. We asked them why that was, and the Trademark Office wrote, "It is incontestable that the applicant is of Asian descent and part of an Asian band. Therefore, there's an association with the disparaging term." In other words, they said we are too Asian to use the mark. In their minds, if you go to the slants.com and you look at our pictures and our footage of us in live concerts, well, people would automatically assume the racial slur because of our ethnic identities and not any other possible definition in the dictionary. But it's really more of a convoluted way of saying anyone can register the slants as long as they're not Asian. So once I heard that, I decided we needed to continue fighting because the government, even though its intention was to protect marginalized communities, was actually using people's race against them. We found that the case with their political identities, with their sexual orientation, with their gender, and anything that was considered controversial by the government would be grounds for them to deny us rights. And so we appealed and appealed, eventually won at the federal circuit. One step below the Supreme Court, they ruled that the law that was being used against us was unconstitutional. 9 out of 12 federal judges agreed that we should have the right to register our band name. Beyond that, we kept fighting, eventually went to the Supreme Court where we were victorious. One of the few unanimous rulings in Supreme Court history, 8-0, every single justice agreed that the law was unconstitutional. Not only was it unconstitutionally vague, but it was also engaging in viewpoint discrimination. For me, this experience has been exciting, inspiring, and incredibly frustrating. It reminded me how important it is to protect free speech. You see, a lot of times people present this false dichotomy that you either have civil rights in one corner and you have civil liberties in the other. But the reality is that if you want to protect civil rights, you have to begin by protecting civil liberties, because those tend to be the rights that marginalized groups don't enjoy the most. We can't have the government choosing winners and losers in terms of who gets police protection, who gets to have the fire department serving them when their house is on fire, who gets protection during a protest, or even who gets to register their trademarks or not. The government is there to protect us, not to infringe upon our rights. So I'm thrilled that the decision was made, that it was unanimous. It struck a resounding chord, showing the importance of the issue, that it was bipartisan, that we all have a vested stake in the right of the First Amendment, and how important it is to fight for those rights. And for me, I believe I'll continue fighting on behalf of marginalized groups because that's what I'm most passionate about. And if and when those kind of skirmishes and issues intersect with free speech, I definitely know where I stand on that. So thank you so much for listening.
Trevor?
Well, thank you, everyone, for coming. Thank you to Heritage. Thank you to Tiffany. Thank you for the beer. I'm from Colorado, so I know that the Flying Dog is actually from Colorado, too. This is the brief that I got signed by Simon Tam. I'll be auctioning it off later, that we wrote in the case. I wrote a good part of this. It's on behalf of Cato and a basket of deplorable people in favor of the ban. Now, I had a particular expertise writing for this brief because I've been in offensive bands, and I know a lot about offensive music because I like offensive music a lot. So they came to me and they said, okay, Trevor, you just get to write all of the band names and everything you want to put in here. And that's what I did, and partially for the brief. Now, it is really important because we're talking about what bands are communicating with their band names. And I think this is an underappreciated part of this case, that the Slants communicated a kind of ethos that they approached. Obviously, if you think of other bands like the Slits, the Queers, NWA, Pansy Division, which was part of a queercore rock movement, another trying to take it back, and Queen is another one where you're trying to take it back. I spent a long time trying to tweet at Pansy Division and the Queers to get them to sign on to our brief, but they just did not return my calls. But you have other band names that communicate what kind of thing is going on. So you have the Sex Pistols, Dead Kennedys, Butthole Surfers, Rape Man, which is a Steve Albini band. I highly suggest that one. Snatch and the Poontangs is a 1970s R&B band. Pussy Galore, one of John Spencer's first bands, and Dying Fetus. Now, here's the important thing about this. Dying Fetus is not a Lawrence Welk cover band. I'm sure you're not surprised. And the Revolting Cocks are not a string quartet. And, of course, the Slits would never open for Paul Anka. Now, the Slants could have called themselves four Asian American men who are very respectful to our diversity as a nation. FAAMWVRDODN, I guess would be their band name. And if you went to their concert and you saw them play Chinese, one of their lyrics in their songs is a Chinese, Japanese, dirty knees, look at these. You might be very offended that a band called Four Very Respectful Asian American, respectful of our diversity as a nation was playing something so offensive to you. So there's a communicative aspect to naming your band the Slants, which I think Simon did a good job of articulating. Of course, it's not just the Slants. Many organizations have adopted and taken on the names that were given to them by other people. This includes the Jesuits, the Methodists, the Mormons, the Quakers. We also have things like Yankees, Impressionist, that was an insult. Suffragette was an insult too back in the day. And of course the appropriation of words like bitch from the LGBT community, bitch, queer, dyke, redneck, cracker, bastard, all these things. Now it brings very interesting questions about how we deal with this. In our brief, we have some footnotes, including the Seinfeld, where Jerry suspects that someone is converted to Judaism so he can tell the jokes. If he remembers this one, he says he wanted to shtickle, and I go, I can say that. And then he makes fun of Catholics. He says, well, I used to be Catholic, so I can do that too. And Jerry says, if this guy gets Polish citizenship, he'll have total joke-telling immunity. He can tell jokes about everyone, which brings up this question of the government said, because they're Asian American, this is particularly bad that they couldn't name themselves this thing. Now, this, of course, brings up a South Park scene that we quoted about how we decide who decides for the community of color, like Asian Americans or African Americans, who decides that we're offended, right? And currently, the PTO was trying to say that we think Asian Americans are offended. Now, there's a great South Park episode called With Apologies to Jesse Jackson that includes the following exchange. Hey, Token, I just want to let you know that everything is cool now. My dad apologized to Jesse Jackson. Oh, I see. I'm supposed to feel better now. Well, yeah. You just don't get it, Stan. Dude, Jesse Jackson said it's okay. Jesse Jackson is not the emperor of black people. He told my dad he was. You have these problems about who can actually validate one of these disparaging remarks, and it's definitely not going to be the PTO. Just to talk a little about the decision itself, it's an interesting decision with multiple parts, and actually it's three decisions. What we really got from one interesting point is we got Justice Samuel Alito, who was my biggest concern in that case, coming out for free speech, which if you know much about his jurisprudence, he has not been very good on what would be generally called offensive speech. In Snyder v. Phelps, which is part of the Westboro Baptist Church case, he wrote, our profound national commitment to free and open debate is not a license for the vicious verbal verbal assault that occurred in this case. In U.S. v. Stevens, which is a case about crush videos, really videos about animals being crushed, he said the court strikes down, this is in dissent, strikes down in its entirety a valuable statute that was enacted not to suppress speech, to prevent horrific acts of animal cruelty. Didn't like the speech in that case. And in U.S. v. Alvarez, which is a case about a guy lying that he won the Congressional Medal of Honor and the Navy Cross and I think several other awards, in dissent with Justices Scalia and Thomas, he said the lies covered by the Stolen Valor Act have no intrinsic value and thus merit no First Amendment protection unless their prohibition would show other expression that fails. So you see that Justice Alito, who ends up writing the majority in this, has not historically been into free speech. I think for him, he saw this as part of the political correctness movement. What I would say, I would put this in a line with Walker v. Sons of Confederate Veterans, which is a case about whether or not the state of Texas could deny a Confederate flag license plate and a very robust Confederate flag. Robust license plate, private license plate system. Another thing we could take away from the case is that Justice Breyer doesn't always turn everything into a balancing and proportionality test, which I think is good. He tends to have a jurisprudence of proportionality. Everything is going to be weighed. It's been called a free-form balancing test. In a case like Reed v. Town of Gilbert, he rejected the mechanical use of categories for a more basic analysis, which is a multi-factor balancing test. It's very hard to predict, but Justice Breyer came on and said, no, we're going to protect this and we're not going to have a multi-factor balancing test. And of course, the court did not fall to political correctness, which of course is a very big thing we talk about now. But I think this is important because I didn't feel the Redskins case, which Eric will talk about, were hanging over them in this question of the very heated time where people don't like what a lot of people are saying and they get very upset. That did not affect their decision that this wasn't unconstitutional. Now, of course, we have the government speech doctrine, which I think is another important part about this. One of the arguments that the government made was that it's hard for me to say this with a straight face, somehow trademarks were government speech. We're turning things into government speech. Now, if you know the Texas license plate case, that is what the court ruled in that case, a strange sort of association of Justice Thomas and the four liberals saying that license plates are government speech. Now, this could push a very scary free speech doctrine because government speech is allowed to be viewpoint discriminatory. It's allowed to be highly censorious. It's if the government is putting up, and this is actually a thing that Justice Alito quoted in his dissent in Walker v. Sons of Texas Confederate Veterans, that the government was putting up propaganda posters or things telling you to save water or save steel during World War II. They're under no obligation to let someone put up posters that say the opposite of that. Now, if we expand government speech, it could get very dangerous, and Walker seemed to do that because it was very strange, as we wrote in the brief in that case. I'm a big Oklahoma Sooners fan, and you can get an Oklahoma Sooners license plate in Texas. And he's gone. You're a Texas fan, right? We do, yes, 4 o'clock. But you can get an Oklahoma Sooners license plate in the state of Texas, which means that apparently the state of Texas is endorsing the Oklahoma Sooners, which I don't think if anyone knows about the state of Texas, that's probably not going to be the case. So what happened in the decision here, we said that they didn't even really entertain the fact that a trademark could be seen as government speech, which I think is very, very valuable because Walker seems to be the outer limits of the government speech doctrine, and that's a very good thing there too. Now, in general, I think we had a very good assertion that the court, that offensive speech is protected, that hate speech is protected. They didn't look twice at that, and despite a lot of particularly left-wing college students who think that hate speech is not protected by the First Amendment, the Supreme Court once again affirmed that, which continues a general trend that in terms of agreement over the last 20 years in particular, we've seen free speech get more protected by the Supreme Court in a lot of cases that were even more extreme than Simon Tam's cases. So it's always been a fun case. I'm really excited too because it's a great teaching case, and it's always important to teach about the First Amendment. As Jim well knows, I've already done one session with a group of high school students who were going to run this with their class and have them do the moot court and pretend to advocate on both sides, and I was teaching them, and so just the facts, the band, everything, it's a great teaching case. And if there's one thing we definitely need right now is we need more teaching and more discussion about the First Amendment and how important it is for people to protect the freedom for the thought they hate, because, of course, if offensive speech and disparaging speech is not protected by the First Amendment, then the First Amendment doesn't mean anything. Popular speech does not need to be protected by the First Amendment. If you say something very popular, you do not need the protections of the First Amendment. And so what we need to get people to understand, as I think Simon kind of alluded to, that the fundamental doctrine of the First Amendment, why it's so important, is it's today you, tomorrow me. Today, you might say that we're going to shut down your speech in some way, but tomorrow it's going to be me if you let that happen. So that in general, this is a very good thing that the court did, and hopefully we can hold the line against expand the government speech doctrine, and I congratulate Simon and his band, which is pretty good. I don't think they're the first all-Asian American dance rock band, though, but I'll give him that because he went to the Supreme Court. Thank you.
Well, I've been given the incredibly brief task of telling you about the Redskins case. I assume anybody who's within the vicinity of Washington, D.C. understands that the PTO has attempted to cancel 6 of the Redskins' marks on the grounds that they are disparaging. After Tam came down, everybody in the case agreed that it controlled and the Redskins win. The government agreed. Pro Football agreed, and even the challengers agreed that it unequivocally controlled, and that was in June or July. That was in July. So it, I suppose, begs the question of what's the Fourth Circuit thinking about? And one can only hope that they're distracted by something else. I called the lawyers in the case. I called Lisa Blatt, who's the lawyer for Pro Football in this case, and asked her, so what's up? Why are they not giving you your order? And she said she had no idea. By the way, just a shout out to Lisa, spectacular appellate brief. Just Lisa does a certain type of appellate law as well as anyone, which is basically to poke her finger in people's eye, tell them they're wrong, and she doesn't care if they don't like being told so. And she did it wonderfully in this instance. So kudos to her, and if you thought his litany of trademarks and band names was bad, just go read her brief. Her litany of trademarks that are offensive was really something. So let's speculate. So this is unabashed speculation on what in the world could be going through the Fourth Circuit's head. I suppose there's 2 reasons why you might delay just issuing the obvious order, which is remand with instructions to reverse. One is because they think they can remand without having to reverse. They clearly have to remand because the rationale of the court below and of the PTO were clearly wrong. But is there breathing room to somehow come to the same result on a different theory? And I suppose I see 2 possible paths, one of which is a function of the really unappealing commercial speech discussions in Justice Alito's opinion, which fortunately Justice Thomas effectively rejected outright, and the other justices effectively rejected outright. The Kennedy opinion effectively rejected, but Justice Alito, in attempting to distinguish the disruption of commerce via discrimination, said, well, even if that were true, it's not narrowly tailored. But of course, that can be fixed. That can be fixed potentially by the PTO, issuing a new ruling saying, well, we construe the statutory command in light of the Supreme Court's ruling to only reach this tiny narrow area of offenses given to minority groups that are subject to the traditional versions of discrimination. The reason I worry about this a little bit, I don't actually worry about this because I think the Supreme Court would smack them in the head if they did it. But I worry about it a little bit because the implications of TAM arguably apply to hostile environment discrimination cases as well. So is it now a hostile environment for me to post a cover of the Slants album in my cubicle at work, or to have Redskins, or God forbid, some more offensive sign up in my cubicle that would offend various and sundry groups at work? And I think that's a closer call under the current laws, though in my free speech world, the answer's obvious, is you can't fire me for having offensive signs, even if it's at work. But that's not today's law. It's probably not where a majority of the court would even go. And so consequently, why is it that you couldn't make a similar argument about the Redskins, that it's offensive to Native Americans who might attend sporting events, much like you would attend any other public restaurant or public event? Why is it not potentially offensive to people who work for the Redskins to have a hostile environment that calls them Redskins? You certainly couldn't have the kike baseball team and not get smacked around in a discrimination suit and a hostile environment suit. So maybe they're thinking of remanding with instructions to reconsider whether or not you could narrow it and address some of Alito's objections that it wasn't sufficiently narrowly tailored to a more direct anti-discrimination purpose. The other way you could go there, though I don't think they will, is, let me preface this by saying I hated the discussion of government speech in the Tam case. I absolutely hated it. I think that whole line of cases is wrongheaded. I think the First Amendment applies to government speech. It allows it in many instances because it wins the balance. But I don't think it's categorically immune. But I'm a minority of maybe 1.5. Maybe Trevor agrees with me, but I'm pretty sure no one else on the planet does. But the logic of government speech, even as described by Justice Alito, was in part that the PTO did not exercise sufficient editorial control and discretion over what trademarks they allowed on. And one might imagine the PTO saying, fine, we'll just up our game. We'll just censor a little more. And consequently, we are exercising more control, and consequently, it is at least government speech. The other thing that I didn't like about the government speech portion of TAM was that it sort of ignores, it treats speech as endorsement. When we have a good line of cases in the free speech area that give speech rights to editors who don't necessarily endorse, but can at least provide a range of acceptable alternatives while excluding others. And the classic example was Hurley and the St. Patrick's Day Parade, where they excluded some groups, included others. Nobody imagined they were endorsing every group, many of which might not have agreed with each other, but they certainly could limit the field as editors. And so to the extent that the government is acting as an editor, not as a direct speaker, I don't know why they wouldn't be exercising their own so-called government speech rights. I did take some encouragement from the fact that Alito didn't want to go there, and so tried to narrow it down, but he narrowed it down in a very Rehnquist-like way, which is, oh, that's different. Right? Rehnquist was the master at this. Oh, I have a case that the logic of which would go here, and the logic of this would go there, but those are different. Period. Next paragraph. Thank you very much. End of opinion. And look, sometimes, as my wife reminds me, sometimes things are not neat and clean and sharp, but they're messy and there are gray areas. And the only thing you really have to say is, I have to draw the line somewhere. I know it's not perfect, so it's different. You just wave your hand, it's different. And I felt that Alito did a lot of that in the government speech area, in the government subsidies area, and in his attempt to distinguish the union cases. So perhaps that's what the Fourth Circuit's thinking about. One can only hope that they're not, and that it's merely an administrative task that they lost track of, but that doesn't sound like a very credible explanation either, does it? So I fear that maybe they're trying to come up with some way to remand it and give an opening to the PTO, or just give time for the government to amend the law and narrow the law and then re-justify the result. That would be all I'd have to say about the Redskins case. I don't know that there's a lot else to say. I mean, there really is literally impossible to distinguish from the Tam case as far as I can tell, other than that quality of workplace environment and public accommodation. But beyond that, it's hard to see. There's much to be encouraged about the Tam case as it would apply to things like the Redskins, things like campus speech. Trevor already talked about it's a good marker for hate speech, that just because you're offended doesn't mean you can't ban it. But once again, I sort of worry a little bit about the hostile environment competing line of cases and where that would go. And I guess I'll stop there and let you guys have a chance for questions, because there's lots more I could say about government speech, but if anyone cares, we'll talk about it in the questions.
Great. Questions?
Hans?
Mr. Cruz, two questions, although I don't want to put you in a bad position with the second one, so you don't have to answer it if you don't want to. My first question is, the members of the Michigan Licensing Board who made that obviously idiotic decision, are they still in their jobs, or are they still there? And the second question is, my understanding is besides the Trademark Office and these licensing boards, that there's a third problem, which is that there was a story came out not too long ago about a single bureaucrat inside the U.S. Department of the Treasury who has the power to approve every single beer label in the United States. And there are people say that he makes very arbitrary and capricious decisions, but that everybody in the beer industry is afraid to criticize him because he has such absolute power.
Do you know his name?
I do know his name.
You do his name, you know that?
And he just recently retired. I have to say, this is the first time where I've actually, after Trevor's recitation of these band names, feel like my names are sort of boring. You
should have. You should see what I left out.
I know what you left
Yeah.
out. So I don't know if they are still in their position. I think they are not. From our standpoint, we build our marketing into our label. There's nothing misleading or unlawful or deceptive about it. These are just liquor commissioners, and this has been a problem for decades since Prohibition and the states took over the regulation of the sale and importation of alcohol. They've exceeded their authority, but it is expensive and difficult to sue a state, and you put yourself in an awkward position when you sue your regulators. So those are all the challenges. The fellow you're talking about, yes, in case you're not aware, the TTB, it used to be the ATF, is the prior organization, the Alcohol, Tobacco, Tariff, and Trade Bureau. There is a single person that looks at the labels and determines if they meet the legal requirements, the statements about health and so forth, and to make sure they're not obscene. But obscenity is pretty loosely defined these days. When our labels first started coming through, there were a lot of questions. After about 6 years, when he would see the Stedman labels come through, his comment to his staff was, "It's that Flying Dog Stedman stuff. Just let it go." But yeah, it's a rather arbitrary, capricious process, and for decades, liquor commissioners across the country have taken it upon themselves to reject labels that they don't like. And it is a blatant violation of the First Amendment.
It should be almost per se unconstitutional. It's like the rule of Bob, like Bob Smith is the law here. And then,
Smith is law.
Whatever his name is.
Yeah, and for us, the idea was, back in the day, craft beer was new. It wasn't that exciting from a label standpoint. We viewed beer as liquid art, and we wanted original art on the label. And we had the good fortune to be connected to Ralph Steadman through Hunter S. Thompson, and he's been doing original art for us for the last 25 years. So it's a real infringement on my ability to communicate to my customers if the government is saying you can't call your beer whatever name you want to call it. And by the way, Raging Bitch has been our #1 selling beer since we released it in December of 2009. I think that's the free market, free enterprise at work.
And Flying Dog and Ralph Steadman are part of the basket of deplorables in our brief. So.
We are.
Question down here.
Print it up.
Thank you. Lady Justice is blind, and our judges are supposed to rule blindly, not judging who is on either side and not putting their personal opinions into the courtroom. Do you feel that now that we're not allowed to bring phones into the courtroom, we're not allowed to bring computers into the courtroom, there are no cameras in the courtroom, our judges are hiding behind their benches and in their chambers making a lot of orders, that these two cases were ended up the way they did because the judges inflicted their own personal feelings into them?
You know more about court process than
Sure. No is the answer. I don't think that is the short answer. And the longer version of that is there's audio and transcript of every argument in front of the court. They have to write a public opinion justifying their behavior. They get criticized from every direction on the planet. And if I had to guess, I'm not sure the result in the Tam case is necessarily the way many of them would have come out as a sort of a matter of personal offense. I'm guessing a number of them might have been disturbed by the name. I'm certain that they would have been disturbed by the gazillion other examples given both by the Pro Football in an amicus brief and by Trevor in his brief and all of those. I'm pretty sure none of the justices were fond of those names. So I don't view this as them hiding behind.
I wasn't asking about the justices. I was basically asking about your beginning judges and the Fourth Circuit judges.
Well, the Fourth Circuit, once again, all that audio is up for grabs. Many circuit courts actually do have video where you can watch the video of that. And once again, they're subject to massive criticism. I thought you were meaning that just the lack of cameras in the courtroom in the Supreme Court.
No, I was talking more of the first court you went to, the federal court, where the case began, and did the judge, do you feel like, I mean, he overstepped his boundaries because you had to take it to the Supreme Court and it was overturned.
Well, I didn't litigate either of these cases, but at least as to the Tam case, the district level judge, while I wish might have been a little more aggressive in defending the First Amendment, at least sort of said, look, there's the statute, and I'm gonna, yes, district court judges let their sort of generic views of the world and of the law influence things. Do I think it's a bias in any worse sense? No. Obviously, you bring your background to any decisions you make, and I would have wished a person with a more libertarian background would have heard the case in the first instance, but be that as it may, I don't impute that to the lack of publicity or the lack of public scrutiny or sunlight. That judge got hammered for these decisions, and the circuit court, I think, came around and did the right thing in the Tam case. And in the Redskins case, the circuit court didn't rule yet. Do I think the bureaucrats at the T-tab might be subject to this? Yes. If your question had been, do I think nameless bureaucrats in the executive branch or in the independent branches think they can get away with stuff because there's less scrutiny on them, the answer to that is definitively yes. But do I think that's true of judges? I guess I spend so much of my time jumping up and down and yelling about why some trial court judge or some circuit judge got it so completely wrong that it boggles the mind, that I think there's plenty of sunshine that gets poured onto their bad decisions.
First of all, it's a great panel, and thank you all for being here. Eric, I'm trying to understand the conflict that you're seeing in terms of possible hostile work environments. I mean, so the Tan case talks about the government being a censor and choosing sides when it does not involve government speech. That seems clear. It seems to me that even involving the government, if you take it inside to a workplace setting, even in a government setting, the government could set reasonable time, place, and manner restrictions in terms of what it is that's getting done. And I mean, there's a lot of stuff that a government couldn't censor that would say have to go into a public library that very clearly would create a hostile work environment if you took photos out of a magazine or excerpts out of a book. And I'm not quite sure I'm seeing why the government's inability to censor this stuff when it's out there in the public at large, the government censoring it, poses a problem to people in a work environment.
So I think in the context of the government saying to a private employer, you will be punished for allowing your employees to display things that are hostile to a particular race or religion or nationality. It wouldn't be the government as employer, because they're not acting in a regulatory fashion. It wouldn't be employers imposing this on their own, because there, again, it's just an employer controlling their own civility. But where you have an employer that says, it's fine if you put up Redskins posters, and in fact, I, the boss, love the Redskins because I'm a local employer, and I have Redskins posters all over, and a Native American comes up and says, that's a hostile work environment. The government does then come in as regulator in the public sector and say, if you don't take that down, you're liable to be sued for discrimination against the Native Americans for being hostile to them. And the reason I worry about this is because Alito seemed to be hedging his bets about this. When you get to the last section, was it 4, of his opinion, it seems like he's holding this off on the side because he doesn't want to say anything that might threaten hostile environments based upon speech, based upon offensive speech. And so pick your group, Arabs, Jews, Catholics, blacks, Hispanics, whatever it is. You could come up with a dozen examples of someone being offended by some poster in a workplace that the boss doesn't force to be removed, and then the government steps in. And that, in some sense, is restrictive behavior by the government that we would presumably are going to continue to enforce through the EOC. And Alito's version of this at least recognizes the tension and does his best to try to preserve it, it seems to me. And that's where I think you could treat the Redskins not as a speaker, but as an employer or as a manager of a public accommodation, the stadium. And at that point, could you have a public accommodation that says, down with Native Americans? Native Americans are terrible, scalping kind of folk? I don't think you could. I think that would be a hostile environment. I think you'd get sued. So how does that play out with the Redskins? And could you go after their trademarks by claiming that the use of their trademarks is hostile to their employees and to their customers?
I want to add, it's sort of not, it's related but not totally related on other things that are coming to John's question, and I don't think this is what the Fourth Circuit is doing, but there's another provision of the Lanham Act that is still out there that prohibits immoral, deceptive, or scandalous matter. That is probably, except for the deceptive part, because that's part of trademark law, but immoral and scandalous is probably just as bad as disparaging, and that's teetered up to fall too.
Question over here.
Well, thank you very much, all, for a great panel. Mr. Caruso, just wanted to ask you, as a business owner, you mentioned that you were threatened with criminal prosecution by a government actor. How does that affect your business practices, and how do these burdensome regulations that are obviously a violation of the First Amendment affect you as a business owner and affect society as a whole?
I sleep like a baby. I wake up every hour crying. What's interesting, I did make a mistake. So just keep in mind the expense to all of this administration. So what we received from Michigan was a letter without a registration number for the beer. So it just slipped through. We didn't know that it wasn't approved. And in fact, the laws on the books are if you ship a beer to Michigan and it's not registered with the state, that it is a felony. And with 50 or 60 liquor licenses, and as you correctly pointed out, individuals, regulators, appointed bureaucrats making these decisions, there's a lot of risk out there in the liquor industry, absolutely.
And a lot of cartels.
Sure.
Yeah.
Anyone else have a question? Oh, please wait for the microphone.
I think it should be a big concern to everybody what you were stating about how people could, around their own little workplace, all of a sudden create a situation for an owner of a business. Do you think there's a way in order to say that each person who has an office within their space has the freedom to do what they want, even if it, I think that's a real issue that I could see people bringing to the EEO in different places and trying to create bigger issues is because of the climate we're in today.
I think it's not really the area I practice in, but I followed a bit, and I think from the EEOC's perspective, the answer is even in your private little office space, if other employees come into it, you don't have complete freedom. You can't necessarily put up the Playboy centerfold or whatever it is that you would care to put up. You can't put up your blood and soil poster if you wanted to necessarily, or worse, signs. They would view that as a hostile work environment and they would go after you. Does that have free speech implications? Yes, absolutely. Have we run past those in the last 50 years? Yes, we have. Will we revisit them in the future? Maybe. But I have my suspicions, and I think that's ultimately what Alito's little last piece was about, is, by the way, we're not going to suddenly open up that can of worms again. Because once you open that can of worms, that's a big can of worms, not just for free speech, but freedom of association. We have a lot of big statutes that have some constitutional difficulties if you let that view resurge. Not that I think it's the wrong view, I just say we may not be willing to undo the work of the 60s, basically.
Thank you, and please, do you have another question? Yeah, I do.
So Jim, I think it's great that you sort of set up this First Amendment series or program afterwards, after your experience. Obviously, there appears to be a bit of a disconnect in terms of and I realize this is opening a totally new area, of free speech on campus. And I'm wondering whether the group that you're now heading up, or this program that talks about the importance of the First Amendment, whether you ever engage with students and kind of what their views are.
I do on a regular basis. Earlier this week, I gave the keynote speech to Hood College, and it was on the First Amendment. I participate in free speech events with Students for Liberty, Young Americans for Freedom, IHS, FIRE, on college campuses, and it is a really big issue. And I think where it gets very confusing is students not understanding the principles of the First Amendment. So why am I optimistic? Because it's not as if they truly understand the principles and what the five freedoms, what those are. It's they don't understand it. And the second is this blurring among students of the right to free speech versus the value of civility, courtesy, and respect, and trying to balance that out. And you see that is very, very blurry in the mind of students. But what's encouraging, even on campuses that are liberal and liberal-oriented, is they are open to better understanding rights versus values, and that you can't equate the two by balancing them out. So yes, I spent as much time as possible. I basically never turned down an opportunity to speak on a college campus. It's inspiring, in spite of the fact that it makes me feel like I'm 100 years old. It's an inspiring activity. Thank you.
Okay. Please join me in thanking our panelists.